Thank you. Good afternoon, everyone. It is February 25th, and it is 4:35 in the afternoon, and we are about to convene our Joint Committee on Judicial Retention. Today, we have three magistrates with us. The Honorable Christine Hoyt is here with us. The Honorable Joseph Lorman is here with us, and the Honorable Brian Valentine. Welcome all three of you. It is a pleasure to meet you, and welcome to the committee. What we would like to do is, I don't know as any of you know any of us, so we will go through introductions first. And but we all are looking at different screens. So again, I will just call out who will be introducing themselves. Representative Shaw.
Thank you, Chair. Hi, my name is Butch Shaw. I'm from Pittsburgh, and I've served in the legislature for 11 years. And glad to be here and welcome everybody.
Thank you.
Nitka.
Hi, I'm Senator Alice Nitka, live in Ludlow, represent all the Windsor County towns plus Mount Holly and Londonderry and other counties, and nice to have you here.
Thank you. Thank you.
And Senator McCormick, you're the next on my screen.
Hi, I'm Dick McCormick. I live in Bethel, and I represent the Windsor County Senate District along with Senator Nitka.
Go down to the second row on my screen is Representative Knott from, yes, you tell me from.
Thanks. Hi. You could do my introduction. So, hi, I'm William Knott. I'm a representative from Rutland City. I'm currently serving my third year in the legislature, and I serve on the House Judiciary Committee.
Thank you. Senator Benning.
So good afternoon, everybody. My name is Joe Benning. I am a state senator from the Caledonia County District. I've also been a practicing attorney since 1984, and thankfully last November had my very last and final family court case, so I don't think I'll be seeing any of you as magistrates.
Thank you, Senator. Representative Coburn.
Hello. Apologies for the sun coming through here. I'm Representative Selena Colburn from Burlington's Chittenden 6-4 district, and I also serve on the House Judiciary Committee.
Thank you. Senator Hardy.
Thank you, Mr. Chair. Good afternoon, everyone. It's nice to meet you, magistrates. I'm Senator Ruth Hardy. I live in East Middlebury, and I represent the Addison district.
Thank you. And I'm the chair of this committee. My name is Representative Chip Troiano. I represent Caledonia 2 District, Hardwick, Stannard, and Walden. So this afternoon, we are here with our three magistrates, and they are about to present a prepared statement of their intent as to why they may want to be retained in their position as magistrates. And we, the committee, are prepared to listen to those and to have the opportunity to ask some questions after their statement is completed. So I think the first one in our book here is the Honorable Christine Hoyt. So we'll start with you. And the mic is yours, as they say.
Thank you very much. Can you hear me, Chairman Troiano?
Yes, we can.
Great.
Thank you.
In line with the introductions I've just heard, I'll say my name is Christine Hoyt and I live in Tunbridge, Vermont. That's in Orange County. But good afternoon, committee members and Chairman Troiano. Thank you for this opportunity to meet with you today to tell you why I'm asking to be retained and to continue to act as a magistrate for the next 6 years. As you may be able to tell, I'm a little bit nervous, so I hope it's okay if you'll forgive me if I use some notes. So as I alluded to in my declaration of candidacy, my path to the bench was somewhat unorthodox. After graduating from Vermont Law School in 1986, I practiced law in a small town for 7 years. After that, I took a position as a case manager with the Vermont Family Court prior to my appointment as a magistrate in 1998. I've had the honor of serving as a magistrate for 22 years. However, this is only the second time that I have gone through retention. Initially, magistrates were not required to go through retention. Rather, there was a process of reappointment and confirmation. While I must admit that the process is a little uncomfortable, somewhat intimidating, and a tiny bit stressful, I did welcome the opportunity for the magistrates to go through retention because I understand that the people of the state of Vermont are entitled to accountability and transparency. In addition, it is one of the rare opportunities for judicial officers to receive feedback regarding their performance. As I'm sure you are aware, there are only 5 magistrates in the state of Vermont, and we cover the entire state. My primary counties where I sit are Windsor and Wyndham. I also cover conflicts in Caledonia, Bennington, and Rutland. The magistrate's jurisdiction is limited by statute, and we hear and determine primarily parentage, temporary parental rights and responsibilities and parent-child contact, temporary spousal maintenance, and child support. I would like to take a few minutes to talk about my experience as a case manager when I first came to the family court prior to my appointment. As a case manager, I worked with parties who had cases pending before the court in an effort to assist them in trying to resolve their issues or identify the contested issues for the court. If the parties were able to resolve some of the issues, I assisted them in memorializing those agreements in writing. If they needed to attend contested hearings, I helped to prepare them for what they could expect in a contested hearing. My work as a case manager with the court was invaluable for many reasons. I saw people at the beginning of the action, often in crisis, and I had an opportunity to see firsthand their fears, their needs, and their wishes. I believe I experienced the unvarnished version at that time, without the robe and without the bench between us. One important thing that I learned from that experience was that everyone who comes into court benefits from compassion and education. It was a priority for me as a case manager to provide information to people in the court process about the process and about resources available to them. As a case manager, I also worked in the clerk's office with the staff, as well as with judges and magistrates. And I saw firsthand the hard work, challenges, and dedication of the judiciary members at all levels. You may ask why I am talking about this experience as a case manager, which was over 20 years ago. The answer is that it is because I believe that I brought the lessons learned as case manager with me to the bench. Those would include the spirit of cooperation with within our judiciary team, the understanding that people who have cases pending in the court are often fearful, that they deserve to be informed, and we should do our best to alleviate their fears and provide access to justice. I also learned that although people are involved in court proceedings, they really do prefer to resolve their own issues rather than leave it to a judicial officer. Magistrates are often the first judicial officer that parties will encounter in their court process. For that reason, it is imperative that we are patient and empathetic, and that we take time to educate people. In my hearings, I usually take time at the beginning of every hearing to ask the parties what it is that they are asking of the court. Early in my career, I think I made assumptions based upon pleadings, and I learned over the years that what you see in writing is not always what people want. I also believe that giving parties an opportunity to resolve issues on their own empowers them. It also results in agreements that will be less likely to be violated. However, if contested hearings are necessary, of course we proceed, and I try to provide the parties with a roadmap. So I tell them in the beginning, this is what we're going to do. This is who will speak first, and this is why. But I assure them that they will have every opportunity to tell the court what they need to tell, but we need to do it in a respectful manner so that we can have a clean record. And at the end of the hearing, I then review what we have done and what will happen next. I would never want people to leave the courtroom after a hearing in front of me and not understand what just happened to them. While the pandemic has changed the way that we conduct hearings, in other words, they're often remote now instead of in person, I strive to conduct my hearings in exactly the same manner. As I pointed out in my declaration of candidacy, there have been a number of changes since my last retention. Changes in the law, changes in the case management system of the court, e-filing, and of course, changes in the way we do business in the judiciary as a result of the pandemic. While I recognize that there was a temporary suspension of domestic cases and that we are not yet able to process cases at the same rate that we did pre-pandemic, I am impressed with the way that my colleagues, including Chief Superior Judge Grierson and the Vermont Supreme Court, have strived to be creative and innovative as we navigate the challenges that we have all faced over the last year. We have endeavored to use remote hearing platforms in order to increase the number of hearings that we have and to continue to provide access to justice. Judicial officers have also taken advantage of these platforms to stay in touch with each other, to confer about new processes and technologies, and to keep abreast of the law so that we can remain competent and continue to be the best judicial officers that we can be. In terms of access to justice, I can say anecdotally that more parties are participating in my hearings now than they did pre-pandemic, which I suspect is a result of having the opportunity to participate from home, on their phone, on their computer, not having to drive, especially if they have barriers to getting to court, transportation, childcare, and they don't have to miss time from work. As I mentioned in my statement, I am a member of the Judicial Education Committee, and I believe that we have increased our educational opportunities for judicial officers during this pandemic by offering a lot of online opportunities for education. Of course, that doesn't take the place of in-person education with the opportunity for spontaneous debate, but I am pleased with the efforts that we have made and the way that those efforts have been received by the judges and magistrates. In closing, I am grateful to have had the opportunity to be a magistrate for the past 22 years, and I would be humbled to continue to do so. Thank you for your time and attention, and I'm happy to answer any questions you may have.
Thank you, Judge Hoyt. So we can begin the questioning with Representative Shaw. You are right to my left here, right to my left.
Thank you, Mr. Chair, but currently I haven't formulated a question for the magistrate, so I think I'll pass.
Would you like me to come back to you?
I will. Oh, wait, I'll let you know.
Okay, thank you. That's fair enough. Senator Nitka, you are sitting to my right. Do you have some questions for the
Hi, Judge Hoyt.
Hello.
You obviously had, you've seen your answers to the questions and everything else, and I really appreciate the great job you've been doing. And I think something that would be helpful for the courts would, as you said, the guidelines for the relatively new law regarding parentage and all that that entails and the multiple parties. And I don't know if that's something that I guess I'd like to hear a few more details of what is the hard part there and what we might do to make that work better.
If you wouldn't mind clarifying,
So,
would you please clarify that question?
so one of the things I read in the information about you was or maybe you said it yourself, was the issue of the parentage cases from the new parentage law where multiple parents, now that we have different persons who weren't before considered parents. And I'm wondering, what is the hardest part about that, sorting out how do you assign child support in those cases?
Oh, the child support guidelines. Okay. So, okay, thank you. Thank you for the clarification. I did reference that in the materials, and the problem is that the way that the Vermont child support guidelines are set up now is that they only allow you to consider two parents. And there's a third option also when a child is with someone other than a parent, a guardian, for example. But you're still, when you calculate child support, you're still only looking at two parents. Mm-hmm. In some of the cases that we now see, there are more than two parents. There are three parents. And so in order to calculate what each parent's respective obligation should be, the guidelines should allow us to put in three different parents. And actually, we need to revamp the guidelines so that we can allocate the parental support among more than two. Does that make sense?
Yes.
Okay. So thus far, it hasn't been a problem for me personally, because in the three parent cases that I've seen, it's been a situation where there's a couple, a biological parent and a spouse, and then on the other side, another biological parent. So those are the cases I've seen thus far. And so I've been creative, but essentially, when you don't have guidelines to accommodate three parents, every case is a deviation. So in other words, as I'm sure you know, we have the Vermont Child Support Guidelines, and that is the amount that the court would deem should be paid. But if you don't have factors to fit within the guidelines, then you have to go outside the guidelines and look at all of the factors under 15 VSA section 659, which is the deviation factor. So it's in three parent cases, it's as though you have no guidelines at all. Have I answered your question?
Yes, I understand what you're saying.
Okay, thank you.
Let's see, I guess the other thing would be in that, you've been there 22 years and as the case manager seem to have figured out so much about the job. Is there any areas that you would like to improve yourself?
Yes, there are. One area where I can use improvement would be in my time management, both on and off the bench. Because I tend to want to give everyone an opportunity to say what they need to say in order to ensure that they are heard, I sometimes spend more time than was allocated for a particular hearing. So that is something that I'm working on. And I've tried some methods that other judges have used. So for example, I know one judge who, keeps track of the time. You use 5 minutes, you use 5 minutes, but then you have to keep track of objections and goes back and forth. It's very distracting to try to keep track of the time that way for me, while I'm also listening to the evidence and trying to make decisions. But I am mindful of the fact that I need to manage the time on the bench better, and it's a work in progress. I would say I have the same issue off the bench. It has been both a burden and a blessing to be able to work from home. I'm sure that many people who are on this call can relate to that. So while it's very convenient to be able to work at home, sometimes I work at home too much. I need to establish some boundaries for my day. but it's been very time consuming with the new processes. Things in Odyssey, the new case management system, take a lot longer than they did with the VTADS process. But anyway, so that's one thing. Another area where I probably could use some improvement would be my ability to, my familiarity with all of the rules of evidence, such that I could make rulings without getting out the rules of evidence and looking things up. I attribute part of that to the fact that we have a relaxed rule of evidence for magistrate hearings. And so I am familiar with the rules of evidence, but I would like to be better in terms of reciting them from the bench without looking them up. Those are two areas I can think of right now.
I see. Oh, thank you very much.
Thank you.
Thank you, Senator. And so we will move to Representative Knott. You're on the top row here with me.
Oh, well, thank you. I don't have any questions at this time. Thanks.
Questions? Okay. And so Senator Hardy, you have some questions for the judge.
I do. Thank you, Mr. Chair. And thank you, Magistrate Hoyt. It was a pleasure to read your file. I have in my notes that everything, all of the comments were excellent, and you should be just really proud of your record and the opinions of your colleagues of your work. It was really a pleasure to read your file, and your cases were clear and easy to understand, even for a layperson like me.
Thank you.
You're welcome. My question, I was really fascinated by your comments about technology and the things that we have been able to learn during the pandemic about how we can better use technology for both professional development and education, and also for access to the court system. And I think it's certainly something that we in the legislature have been learning and could learn more. Particularly, we don't have very good professional development in the legislature, and I'd love to do more of that on our off sessions if possible. But more specifically, I'm wondering if you could talk about the access to this court system for the people you're seeing in your courtroom, your virtual courtroom, and how that's worked. You said more people are participating in your proceedings, and how are you managing that? And if you could speak more about why that's happening and how that's happening, that would be helpful.
Sure. So we begin, we have a platform called WebEx, which you may be familiar with, that allows us to conduct hearings remotely. There is a recorder and a court officer in the courtroom, but we also have big screens now. I think at the time that I wrote my statement, we were still waiting for the screens to be installed, and they are now there. So what happens is that if I am conducting hearings from home, I have a home office upstairs with a bench, so to speak, behind me. I wear my robe, even though I'm from home, in order to continue to have some sense of seriousness and decorum in the virtual courtroom. Everyone gets an invitation to the meeting, and we all join the meeting. And then sometimes people are on the phone, sometimes they are participating via video, and sometimes they're in the courtroom. And sometimes you'll have all three at the same time. So it can be a little bit challenging, but I have found over the past year, because it's been about a year now that my counties have had Odyssey in place, and we've been using WebEx for at least 6 months, that people they're starting to become more comfortable with it. They're starting to get it. And we are getting better in the judiciary about sending notices that gives the people more clear information and direction about how to join the meeting or how to participate. So having said that, we do require that people file documents ahead of time. That has been a little bit of a challenge, but we do the best we can. And again, I think people are getting used to it. But to answer your question about access to justice, as I said in my opening statement, it has been my experience that more people are participating in my hearings now virtually than they did prior to the pandemic. And as I said, I believe it's because, it's a lot of the people that we see have complicated life situations, and they have jobs, and they don't want to have to leave their job to go to court, because right now, if their hearing is an hour, it literally takes an hour, hopefully, if I manage my time right. But otherwise, prior to that, we live in a very rural area. It might have been 3 hours, an hour coming, an hour in the hearing, an hour going. So I hope I'm answering your question.
Excuse me. Yes, you are. So by more people participating, do you mean you have more witnesses, or is it just that people are showing up when before you had a lot of no-shows? Or that's it. So yes. You have fewer no-shows.
Correct.
And do you think this is a platform and process that should continue after the pandemic as an option for people?
Absolutely. I absolutely do. I am not what you would call tech savvy, but I have embraced this new system, and I think other people are too. And I've come to see the benefits of it, and this is probably the biggest one. So yes, I do anticipate, and I certainly hope that we will continue to offer this remote access, even if we, the judges and magistrates, go back into the courtroom. Mm-hmm. And I would not be opposed to that at all. In fact, I would welcome it.
So something like you have 2 days a week where you're doing remote hearings, and 3 days a week, or however your schedule works, 3 days a week where you're having in person, or something like that, where you still give people an option of doing the remote?
Well, actually, I was thinking that regardless of where I am when I am conducting my hearings, that we should offer the litigants, the parties, the option to participate by telephone or by video.
Oh, so some people would be remote and some people could be in person. So there would be mixed. Okay, I understand.
That's right. And the way and the reason that would work now is because we now have these big screens in the courtroom. So if I am there, or even if I'm home and one person is in the courtroom and someone else is on video, they can see each other, which I think is important. Now, having said that, some people still call in, and I know that there are some judges who are not as comfortable with that. Some people think it provides less opportunity to assess credibility. That has not been my experience. And part of that may be because even prior to the pandemic, a lot of some child support cases that are filed under the Uniform Interstate Family Support Act required that we allow participants from out of state to participate by telephone. So it wasn't that huge a leap for me to move on to this platform.
Got it. Well, this is really interesting conversation. I won't take more time on this, but we were literally talking about the same thing this morning in the context of healthcare delivery in the Senate Health and Welfare Committee. So I think it's a conversation that's worth having no matter what field you work in and how we learn from the pandemic. So I was really appreciative to see you address it directly in your file. So thank you for your time and for your good work.
Thank you.
Thank you, Senator. Representative Coburn, you have some questions for the judge.
Senator Nitka actually asked the question that I had planned to ask, which was just to hear you talk a little bit more about the impacts of the parentage law on child support. And so thank you for that. And so maybe I'll just ask a question I've asked some judges in the past, which is just if you could reflect on what you do in your work kind of in an ongoing way to address any implicit bias that you might have, be sort of continually you know, keeping that in check as in your work as a judge?
So I try to be mindful about implicit bias, and I try to take advantage of educational opportunities to learn more about implicit bias. Actually, last year at Judicial College, we had a course on well, it wasn't exactly implicit bias. It was more about racial equity, but we are talking about having a course this year on implicit bias. It's obviously an ongoing dialogue that I have with myself, in addition to others. And all I can say is that I take every opportunity to learn more about things that I may think I know but don't know. And it's on my radar screen. Not sure if that answers your question.
It does. Thank you.
Thank you.
I probably should have not, probably just should have said bias, because of course we're all capable of explicit bias too. And I include myself very much in that reality. But yes, thank you for your answer.
Thank you.
Thank you, Representative Coburn. Senator Benning, you have some questions for the judge. Where did he go? Oh, we caught you out of your chair, Joe. Do you have some questions for the judge, Senator Benning?
Yeah, sorry about that, Chip. I've been bounced several times from the internet all of a sudden, and I don't know why.
Okay.
Magistrate Hoyt, if you give me a second.
Absolutely.
So I want to pick up on something that Senator Nitka said. I'm curious. We had this discussion back in the late 80s when we were coming up with the idea of child support worksheets, and the possibility that families, once broken up, have a tendency to subsequently, each partner will pick up an additional partner, then they'll break up again, and that would, in my eyes, almost necessitate a constant repetition of people having to come back to your court and refile based on income of the new family unit. And I'm curious to know whether that has figured into your mix as to why it might be a good idea to include additional spouses.
Okay. Let me make sure I understand. Well, actually, let me make a statement and then we'll see if I've answered your question. So this is probably something that you already know, but when we calculate child support pursuant to the Vermont Child Support Guidelines, we are not taking into consideration the income of spouses or partners who may reside in the house. The only time when we calculate support under the guidelines, we are only looking at the parents and a few factors related to health insurance, childcare, additional dependents, et cetera. The only time we are looking at the resource of a spouse or a partner living in the same home is if someone asks to go outside the Vermont Child Support Guidelines, in which case we're looking at a deviation under 15 VSA section 659. So I say that because if that's the case and there's no deviation, then the partner changing shouldn't necessarily impact the Vermont Child Support Guidelines. But maybe I'm misunderstanding your question.
Well, it could be that I misinterpreted what you said to Senator Nitka. You were arguing for an additional spouse to be calculated into the mix. I took that to mean the guidelines and the child support calculations would have to incorporate that additional third party.
So I did indicate that there should be consideration of a third parent, but that person wouldn't necessarily be a spouse. I did give the example. I gave the example of 3 parents, 1 couple, mom and a spouse, and the dad, but that wouldn't necessarily always be the case. You could have 3 parents, and none of which are married. So maybe I confused things by using the example that I did. But you could have 3 parents. One could be about two biological parents, and then a de facto parent. And they could all live in separate houses. And the question would be, how do we allocate the support for the child who has these 3 parents under the guidelines, which we are not able to do now?
Okay, I think we're on the same page. I'm curious though, when you add that 3rd unit, obviously the intent would be to benefit the child because that's the overall desire.
Right.
But as relationships come and go outside of the initial biological parents, or if it was artificial insemination or any of the factors that might lead the initial couple who broke up to go their separate ways, you have 2 people that are involved. Normally we calculate those 2 people, and through the years as relationships changed, I'm just wondering, are you thinking that we would add another person along the way into the calculations for the benefit of the child?
Only if that parent has been found to be a parent under the Vermont Parentage Act. So the fact that they're a spouse of the parent is not determinative.
Yeah, I should
And-
not
and
have
so
used that term.
What's that?
I should not have used that term. You're right.
Oh, that's okay. I just want to make sure that I'm answering your question. So I don't see it as people going in and out of the child's life, because from my perspective, if a parent comes to court and asks to be determined to be a parent, whether it's based upon a presumption, genetics, or de facto, once that parentage determination is made, it doesn't go away. It brings with it all of the rights and responsibilities that any parent would have for a child. So regardless of whether or not that new parent, third parent relationship with the other parents terminates, from this court's perspective, my perspective, it wouldn't change things.
Okay, I got you. One other question, it's quick. The Odyssey system and the e-filing that is now going on, my neck of the woods, the Northeast Kingdom, has been chosen as the last portion of the state to have that roll out. And we have not yet experienced e-filing as you are now practicing it. I'm curious as to whether or not pro se individuals have struggled with filing 813 income and assets affidavits and the like in your court.
The answer is yes, but we are making accommodations. So my understanding is that at this time, self-represented litigants are not required to use e-filing unless they sign up to do so. In my experience, not many are signing up to do so. So right now, their options are they can email it to the JUD, judiciary email in the court in which the case is pending. They can hand deliver the documents to the court, which is what I see most of them doing. Or they can e-file them. So it's, so yes, it has been challenging. Pre-Odyssey, as I'm sure you're aware, most of the time, pro se litigants would come to court with their paperwork or without their paperwork, and then they would fill out their paperwork and we would share it with everyone. So that has been somewhat problematic. We are trying to make our notices clearer and less cluttered to put people on notice about what it is that they need to do in terms of providing that paperwork. And I would say that, we're, at least I am pretty accommodating, understanding that this is new. But to answer your question, they are not required to e-file, and they don't appear to be taking advantage of that opportunity yet.
Okay, thank you.
Thank you.
Thank you, Senator Benning. Senator McCormick.
Thank you. Senator, I'm the third person this afternoon to mention Senator Nitka. She stole my thunder. She asked the question that I was going to ask, and which was namely, what do you still have to work on? What do you see in yourself as something you need to work on? And it's a strange question. The reason I was going to ask it is because usually there's at least some negative comments that we can have to deal with. And even the people who get almost overwhelmingly positive have one or two negative comments. And so to do due diligence, we explore that. In this case, if there was anything negative in the comments about you, I missed them. People think you're doing a great job. So I guess I'll just, and since my thunder has been stolen, I'll just give my compliments and leave it at that.
Thank you very much.
Thank you, Senator. Representative Shaw, anything come up?
Thank you, Mr. Chair.
Okay. Okay. Well, thank you.
So,
Judge Hoyt, I just wanted to kind of echo what what Senator McCormick just related to you. Your grades of 100% vote for retention. The comments that your preparedness and your temperament in the courtroom are all good. Your attention to the litigants and allowing the parties to say their piece all gave us a picture of someone whose years of experience in this job, I guess we would call it, is really, without question, one of the better folks to continue on this. So I'll just thank you for your work and conclude this part of your part of the hearing.
Thank you very much, Chairman, and thank you to the committee members again for your time and attention.
Okay, thank you. So in proceeding along, as folks are listed in our book, I would go to Judge Lorman. Judge Lorman, welcome. Good to see you here this evening. It is evening by now. We would open it up to your statement as to why you would like to be retained.
Thank you. Representative Troiano, members of the committee, good evening. Thank you for having me here today. It's an honor to be here to discuss my humble request to continue serving the people of Vermont. My name is Joe Lorman, and for about 3 years now, I've been the Superior Court Magistrate for Rutland, Bennington, and Addison counties. As you know, magistrates primarily hear child support cases, but can also hear parentage, temporary parental rights and responsibilities, and parent-child contact, as well as temporary spousal maintenance cases. My work as a magistrate has been undoubtedly the most challenging and rewarding of my career. This is quite simply the best job I've ever had. I love coming into work every day because in this position, I get to serve the public and the interests of children and families. Like all of you, I've devoted much of my career to public service, and I hope to continue to do so. That's why I'm seeking retention. Ladies and gentlemen, I come before you today with no ego. My only objective is to learn as much as possible from this process so that if I'm permitted to continue as magistrate, I'll be able to best serve the litigants and staff in the courtroom. This is my first experience with retention. In fact, I have the least experience of all the judicial officers that you'll meet this year. And to be sure, I have made mistakes along the way, and I still have much to learn. Where there are positive themes in my survey results, please understand that those successes wouldn't have been possible without the hard work and the invaluable support of the court staff. I could not be successful without them, and I have the greatest respect and admiration for them all. Where you find adverse responses or comments in the results, I take full responsibility for them, and I promise to learn from them going forward. It's fair to say that I was surprised and humbled by certain survey results and some of the adverse comments, particularly those from the court staff. I had believed that I had an excellent relationship with the staff and had been doing things the right way, always with an eye toward making things as easy as possible, not just on them, but also the attorneys and the litigants. It's evident that at least some of them see it differently. I acknowledge and take those results and comments very seriously. If I may be permitted, I'd like to address some of them now in the hopes of providing the committee with some context. First, there was an indication that I'm not available to hear emergency matters, and indeed this category results in the lowest weighted average I received on the attorney surveys. I'd like to point out that there are no emergency hearings in the child support docket, and thus I'm unable to make myself available in that way. But in the future, I will do a better job making that clear to the parties if emergency relief is nevertheless requested. Next, it was suggested that the court does not always issue decisions promptly, and I agree. As I said in my retention statement, I've tried very hard to make decisions in a timely fashion, and the best way to do that is to issue decisions from the bench. And in the overwhelming majority of cases, that's what I've done. And the parties, when I do that, leave the court that day knowing the court's decision. However, it's not always possible to rule from the bench, and matters must sometimes be taken under advisement. Of those I've taken under advisement, some have been under advisement for longer than I would have liked. Finding time to write decisions is difficult. I have hearings scheduled 5 days a week with just 1 day per month devoted to decision writing. And so I often write on the weekends and the evenings to keep up. But with that said, I agree with the concerns expressed, and this is an area in which I can and will improve in the future. There's also evidently the perception among some that I'm disinterested or that I don't want to hold hearings or that I don't start hearings on time. I take responsibility for creating that perception, and I'm grateful for the survey results because without them, I wouldn't have known it was creating concerns. With respect to my level of interest in the position, I assure you it could not be higher. I love this job and the ability that it affords me to serve the public. Even now, when all hearings are held remotely, I still come into court 5 days a week rather than doing them from home. I do that for the simple reason that I love being there. And as to starting hearings on time, the child support docket is a little different than other dockets where superior judges may begin their hearings immediately in certain cases, in that the Office of Child Support is a party to most of our hearings. And so I have continued, I should say, a long-standing practice employed by my predecessors, whereby OCS meets with the parties for 10 or so minutes prior to the start of the hearing in order to attempt resolution. I continued this practice because I saw how well it worked in my previous position as attorney for OCS. The method results in a great deal of agreements, which obviate the need for the hearing and saves the court staff the time that would otherwise have been taken up with a scheduled contested hearing. In the period between January of 2020 and just yesterday, in Rutland County alone, approximately 90 cases reached agreement using this method. And so when that happens, it frees up both the staff and the magistrate to do other necessary work. When an agreement is reached, we go on the record and finalize it. If there's no agreement reached, we go on the record for a contested hearing and the court issues a decision. In instances where hearings are not strictly necessary and in order to save the staff and the court's time, I have dealt with agreed upon requests to continue or in cases where continuance is necessary for lack of service or other reasons by issuing orders from chambers without going on the record. The orders detail what actions were taken, the reasons why they were taken, and the next steps. In hindsight, I believe this was a mistake because I unwittingly created the impression among some that I was disinterested, unprepared, or did not want to go on the record. I can assure you that this is not the case. And as soon as I learned of those concerns from reading the surveys, I ceased that practice on the next business day. And I regret that it seems to have caused inconvenience to at least some of the court staff. A word on my preparedness, if I might. While I take responsibility for giving some folks the impression that I'm not prepared for hearings, I do prepare extensively for each of them. I've created a detailed prep sheet that I complete for every hearing. And even when commuting from Rutland to Barre on a regular basis in my first year or more, I routinely arrived an hour early to prepare for the day's cases. But since I learned of the concerns raised in the surveys, I've been making sure to enter all hearings within seconds after I'm told that the parties are ready. I'll continue to do so. The discussion of preparedness also calls to mind a comment from someone who believed that I took a phone call in chambers, thus delaying a hearing. While I can't speak to that particular hearing, obviously, because I'm not sure who the commenter was, it is possible that I was on the phone. However, if I were, it was to discuss an issue in that particular case with another magistrate, which is something that we do from time to time. And so I would just like the committee to know that I would never delay a court proceeding to take a personal phone call if that's the inference that was drawn from that comment. Neither would I enter the court without wearing a mask, as another comment suggested. I take the COVID-19 pandemic and the court's response to it very seriously, both because I think it's, I should say, I must confess that I'm confused by that comment, and I routinely wear a mask, even in remote hearings, because I think it's important to model that behavior, and also because I want to have a mask on in case someone should enter the room. I won't need to scramble to find it. I do recall early on in the mask wearing mandate that I remembered during the short solo walk from my chambers to the bench that I had forgotten my mask and that I needed to go back and get it. But I have not, and I would never be in court or hold a hearing without wearing a mask. And if retained, I will continue to follow all COVID guidelines. Lastly, I was perhaps most dismayed by the staff's responses to the question about whether I act with compassion, sensitivity, courtesy, and without arrogance. I've genuinely made a concerted effort to treat everyone with respect, kindness, and consideration. I've striven to make the courtroom as welcoming a place as possible for everyone. Indeed, had you asked me 2 weeks ago, I probably would have told you that this was perhaps my best quality as a magistrate. While attorneys did not seem to take as dim a view of my performance in this area, I'm disappointed to learn that some of the court staff evidently did, and I must and will do better going forward. In closing, I appreciate the opportunity to discuss my candidacy for retention with you. While I believe that the surveys demonstrate that I have had a modest level of success during my short time on the bench, it's also clear that there's room for improvement. If I'm permitted to continue as magistrate, I'm determined to make those improvements. It's been, without a doubt, the biggest honor of my life to be counted among the number of the fine men and women of Vermont's outstanding judiciary. I humbly request retention so that I may continue to learn, improve, and serve the people of Vermont. Thank you very much, and I would be happy to answer any questions that you might have.
Thank you, Judge. So we can start with Senator Benning. Do you have some questions for the judge?
Having real problems with my laptop at home this evening. I don't know what's going on.
Uh-oh.
Magistrate Lorman, if I cut out, that's okay. You can move on to the next person.
Okay.
Let me say I've been on the committee for a fairly lengthy period of time, probably more than 10 years now. And I have to say honestly that when I saw your score results, I was very concerned. You have indicated a desire to do better, but a desire by itself does not necessarily leave me personally with a whole lot of comfort. Is there some game plan that you have moving forward in order to address the problems that have been raised?
Yeah, I'm glad you asked that, Senator. So obviously I've been giving that a lot of thought since I read the surveys and was, at least from the staff, somewhat taken aback. I did note that of the 15 folks that responded to the attorney surveys, I was humbled that 12 of them recommended that I be retained. But the staff surveys were really I think, what were most surprising to me. And so it does indicate to me, despite the fact that in my daily interactions with the staff, I don't perceive that attitude, that there is certainly something going on that needs to be addressed. And so my plan, although I've not had a lot of time to discuss it with the other folks required, would be to speak with not only Judge Grierson, but also the presiding judges of the 3 courts that I sit in, as well as the court operations managers, to try to put in place some sort of a way for the staff to express concerns as they arise, and to hopefully allow me to best repair, to the extent that there are damaged relationships, to try to repair those. They're not issues, I think, that sometimes people feel comfortable on the staff, feel comfortable mentioning to a judicial officer, and I totally understand that. But I also think that there could be a better way to learn about and try to correct those, rather than learning of them as part of the retention process only every so many years. So I think my plan would be to if they're willing, try to work with Judge Grierson and the presiding judges, as well as the court operations managers, to address some of those issues. I've also, as I mentioned in my statement, to the extent that I'm able, have changed practices that I think may have contributed to some of those results. And so I'm hopeful that that will be of some use in that regard.
Have you ever thought about holding a bench bar conference with just the staff? Because I will agree with you that it is the staff numbers that are the most difficult to look at. But I'm curious, it's a limited group of people. Do you ever have the opportunity to just go to the courthouse one day, say, I'd like to have a bench bar conference with all the staff, and say that you're cognizant of the remarks, you're thinking about what has been said, and in self-reflection, you want to give people an opportunity to freely open conversation with you? I mean, I have to tell you that as an attorney for 37 years, I've been in the position many times of running afoul of some judge where I felt like we just never got off on the right foot. And there's been at least one distinct occasion where I walked into the judge's chambers and I said, I don't want to continue this way. You probably don't want to continue this way. What can we do to get around this? So I don't come at this by any means as somebody with clean hands necessarily, but one of the things I have found that works is to literally open the door and allow people to come in and have a conversation with
you. I would agree with that, Senator, and thank you for that suggestion. To answer your question, I have not done that yet, and it's not something, to my knowledge, that has been done. I have thought about it and was thinking of raising that, as I mentioned, with the presiding judges or Judge Grierson, just to sort of clear that, because I'm not sure if it's something that's normally done, and I don't want to be perceived to do anything that looks like I'm trying to figure out who made what comment, or in any way make the staff feel as though there are going to be any sort of retaliation or any repercussions for their comments. So I am certainly open to doing that. I think it's a great idea. I guess I would want to clear it first to make sure that it's appropriate for me to do. But then, yes, I'm certainly open to that.
Fair enough. Thanks.
Thank you.
Representative Troiano, can I interrupt for 1 second? For some reason, I logged into YouTube. It says that we're live, but I can't seem to find it. So I'm working on it, but I just want to let you know that I'm not really sure where it is. Oh.
Chip, you're muted.
Should we take a brief recess to see if you can get that fixed, Peggy, or you want
I wouldn't say so. I think it's somewhere because it says it's live. I just have to figure out where the heck it is.
Okay, fair enough.
I'll let you know.
Peggy?
Yep.
If you follow, like if you click on the live on YouTube, and that little drop down menu, there's a view stream on YouTube, and I was able to get to it just now. using that. So you're right that it's somewhere, and following that link may help you figure out the path. Because I actually came in and heard it like on YouTube, you were describing the dilemma of that. So
Okay,
we're definitely streaming to somewhere.
Okay, I'll let you guys know.
Okay, thank you, Peggy. So we will continue. Senator Benning, you're finished your questioning?
I did.
Okay, thank you. Representative Colburn, do you have some questions for the judge?
I do, but building on Senator Benning's, well, first of all, thank you for joining us and just for your candor in all of your remarks. And I just building on Senator Benning's question, I'm wondering if you were going to, in addition to some of the other steps that you've outlined, seek any like additional training or professional development or things along those lines to help address some of the concerns that have come forward here in your surveys. Do you have a sense of where you might concentrate any efforts along those lines?
Well, I'm certainly open to that and would love to do so. I obviously just received these survey results the Friday before last, and so haven't really been able to, I think, line up anything yet. I think that may take some time, but I'm certainly open to that. It's something that I would have to do in conjunction with probably the Chief Superior Judge and or the presiding judges. But to that point, Magistrate Hoyt, who you've all just met, has been gracious enough from the time that I was appointed actually to agree to serve as my mentor. And so she's been sort of an invaluable resource. And so she'll probably be happy to hear this, but if she's willing, I'd certainly be interested in sort of continuing that relationship and obviously open to considering anything else. But as of now, nothing is on the schedule. Let's put it that way.
And have you had a chance to talk to other folks like Judge Grierson or Magistrate Hoyt or others who you view as mentors or just valuable resources about the results yet, and just start to kind of get some support in analyzing them and thinking about next steps for yourself? Or it's sounding like that's more still on your to-do list?
It is. The answer is no, I haven't. They both Magistrate Hoyt and Grierson, as you know, are also going for retention at this point. So, they're both, as you folks are well aware, spinning a lot of plates under the best of circumstances. And so, while they're going through this process with me, I did not feel that I wanted to sort of heap that on them at this point. But I certainly am. I certainly do intend to circle back and. Believe me, there's nothing I would like to do more than to address whatever the issue is that's causing some folks to be displeased, I guess. Again, I, for my part, felt as though I was being as considerate as I really could be. And so I was, taken aback by the responses. And obviously, it pains me to read those things, and nobody likes to read adverse comments about themselves. But I'm certainly willing to take those to heart and to act on them.
Are you finished?
Yes. Thank you. Sorry.
You.
What my thank you was meant to indicate. Thank you.
Senator McCormick, do you have some questions for the judge?
Thanks. Yeah, let me just say, first of all, I've been a teacher in the state college system. One of the practices there is student evaluations of instructors. And also in another life, I was a musician. And I never got a bad review, but I certainly got heckled from time to time. It's no fun. It hurts. And even if you're getting mainly good reviews, the bad comments hurt. 2 years ago, we had a judge who certainly was respected by his colleagues and seemed to be, all else being equal, a pretty good judge, except that there was a pattern of comments about him being haughty and imperious and intimidating. And he seemed quite shocked at how he was being characterized, but nevertheless took it to heart. And I don't know if we've done a follow-up on it yet, but I felt at the time that we finished up that we had resolved the problem, which is you owe it to the public not to not to put them before a judge who behaves badly towards them. And yet this was a guy who seemed to be, all else being equal, doing a reasonably good job, if only he would work on this. And he got into a whole program with mentoring. I'm wondering, you say you're getting some advice. How would you feel about a really formalized mentoring program?
I'm willing to do whatever is necessary, Senator. So I would be happy to do that if the committee feels that that's appropriate.
That's an answer. Thank you, Mr. Chairman. Thank you, Judge. That's all I have right now.
Thank you, Senator. Representative Knott, do you have some questions for the judge?
Thank you. I did have some questions in regards to some of the comments, and most were answered during your introduction to most degree. The one thing I would ask you to please touch on a little more is you've talked about the need to, when they're not issued from the bench, issue decisions more quickly. And could you talk a bit more about your planning to address that, please?
Sure. So I have, as I mentioned, I think in the vast majority of cases, issued decisions promptly. And to be sure, there have been cases that I took under advisement that did take longer than I would have liked to issue them. And so what I need to do as far as those cases are concerned is to really just manage my time better. What I've tried to do, I think, is just work more, work weekends, work nights, and that's not probably a sustainable way to do it. So I need to get better at one of the things that I've seen folks do, which is writing their decisions during the day while they're doing other cases and sort of transitioning between one and the other, and also sort of refocusing on that opinion that they're writing and sort of tapping away at that in between. That's not something that I'm accustomed to doing, and I'm used to being a sort of set time aside to work on it and sort of get it done kind of a guy. I definitely need to get better at that. And so, that's a time management issue. That's something that I think you heard Magistrate Hoyt touch on. I definitely need to get better at that. I've also, for my own part, started keeping my own files, my own record of every case I take under advisement, when it was taken under advisement, and when I issue the decision, I keep track of that as well. So that helps me to focus. I check that basically every day, so there's no danger that a case could get lost, although that's never happened. Those are mainly the ways so far that I've come up with to try to address that issue.
All right, thank you. I'm all set.
Thank you.
Thank you, Representative. Senator Nitka, please. You're muted. Senator, you're muted.
Sorry about that. I look like I'm at some kind of haunted house here with the light in my room. But anyway, Judge Lerman, I think that, as you said, it's very hard to receive the survey comments. But I feel it does give you, as you said, some insight into where you want to improve. And, and it sounds like you've taken all of that to heart and are looking at ways to do it. As Senator McCormick said, mentoring might be the way to go in terms of, something formal. And certainly you would not be the first judge to have that be recommended. And to have it successful. I can think of some judges who wound up being very, very good judges and admired, who had some trouble on their first retention. And I think the most important part is getting the decisions done on time. That's what can really sink somebody. And it sounds like you have a terrible schedule, of course, in terms of, the court being there in the courtroom, having only one day a month that you write your decisions is certainly not enough with all the cases that you're handling. And maybe I realize they don't all need something, but I think that's the area to really need some work. And then, I think, and the other suggestion of having a bench meeting and meeting with people to get the air cleared on a lot of this stuff, rather than letting it build up more, would be really good. I think some of it's really a big time learning process, and you haven't been on the bench that long. So I think, I think certainly Judge Grierson would work with you on that, and whoever else, maybe someone from the Bar Association, to get you in the right place. So I think you've heard all the criticism. I think, I think of one where you inspires respect. You got, a 7 very good and 2 excellent there. And at the same time, 3 poor. So it's hard to know what people were thinking, but I think those are the things you'd want to work on. So thank you, and my best to you.
Great. Thank you very much, Senator.
Thank you, Senator. Representative Shaw, you have some questions for the judge.
I do. Thank you, Mr. Chair. So, Judge Lorman, I was looking at your survey results and was a little disappointed, but then I understand you've been a magistrate just 3 years. And we've heard some folks talking throughout these hearings that it takes 5 years to learn how to be a judge or a magistrate. So I hope you'll take the survey results and I hear that you're trying or planning to do it, and consider the survey as a toolbox, and it's full of tools for you to take out and use and learn from. I appreciate all the other panelists and especially Senator McCormick talking about formalized help and going forward. But I noticed in your statement for retention, something that I had never considered is the isolation that you can feel now as a magistrate, and the stress that you now feel. How do you handle that, and how can you plan to handle it? And do you think it affects does it affect your work? I guess we'll leave it at that.
So thank you for that question, Representative Shaw. I do not think that it affects my work, but it is, and again, obviously, I'm not complaining. The benefits of this position far outweigh any of the negatives, as I said in my statement. But there is an element of isolation. I think you've probably heard other judges mention, judicial officers mention it before. It is something that I'm not typically accustomed to. I tend to be sort of a social person. And so when I took this position, I certainly knew that was going to be part of it. But at the same time, I am a person, I'm a single person. I do live alone. And so, when I'm in court, as a judge, you are sort of isolated by nature in chambers most often. And so there's some of that going on. And then obviously the COVID pandemic has not helped that situation at all. So, we're not permitted to gather with other households. Because I live alone, I get to gather with my parents. That's the one household that I chose. So they're seeing a lot of me. They tell me that they don't mind it, but I'm not convinced. But so, yeah, I mean, it is a real thing. The way I try to sort of deal with it is just to keep in touch with people as much as I can, through Zoom, by visiting my folks, by trying to be social and chat with folks at the courthouse when that's available, and to just sort of try to wait out weather this storm. So hopefully once the pandemic passes, we'll be able to return to some sort of semblance of normalcy. Following the COVID guidelines this year, I wasn't able to even, and this is true of a lot of people, but I wasn't able to go to my family's, Thanksgivings or Christmas dinner and things like that, things that we've all sort of dealt with. But yeah, so there is an isolation component, and my hope is that once the pandemic is over, that there'll be more opportunities to sort of help with that.
Thank you.
If that answers your question, sir.
It does. Thank you.
Thank you.
Representative Shaw, that's okay. And Senator Hardy, you have some questions.
Yes, thank you, Mr. Chair. And thank you, Magistrate Lorman, for being here with us tonight. And I appreciate your humility about the situation. I share the concerns of my colleagues with your record, at least as presented to us in your application. Your scores overall, usually we see scores or comments where we're talking about a few comments that are negative, and then we focus on those, as one of my colleagues said. But yours is kind of the opposite, and it was very troubling to me to read it. And I am struggling right now to hear from you a reason to retain you. And I know that sounds harsh, but we do have, usually when we have concerns or additional questions for a judge or a magistrate, we have you back. And I'd really appreciate it if you could, over the next couple weeks, think about why we should retain you and come back and make a case to us about what your plan is and what you're going to do to improve your performance, improve the perception of your performance and your relationships at the court. And really make the case to us, because I haven't really heard it from you tonight. And I need a reason to vote to retain you, because at this point, I just will be honest, your record and what I've heard from you tonight doesn't give me a good reason to retain you. I take very seriously, as I'm sure all of us do, and I'm sure you do, that our court system is, it's incredibly important to the citizens of our state and the application of justice, and that they feel welcome and served well by the courts and by our judicial officers. And I'm concerned that they don't feel that from you, as reflected particularly in the comments from the staff, but also from the attorneys. So I'm happy to hear what you have to say now, but I'm going to ask my colleagues that we have you back, and I want to hear from you a plan and a reason to retain you. So thank you.
All right. Well, thank you for your comments, Senator Hardy. I'm more than willing to do that. I appreciate your concerns and share them. Obviously, I agree with you that the people of the state of Vermont rely on the judiciary. It's very important. Obviously, I want to be the best judicial officer that I can be. And so I'm, more than willing to comply with that request if that's what the committee would like.
Thank you.
Thank you.
So Judge Lorman, there's a few things, your time management in writing your opinions struck me, because when I write very scattered. I just, thoughts come into my head and I write them down, and then I have to spend a fair amount of time editing. So I can appreciate the time element that it takes to write such things. I worked in the criminal justice system for 35 years. My sister is a retired appellate judge in New Jersey. So a number of the things that you touched on were familiar to me, and including the isolation piece. I watched her go through that. When my sister was elevated to the bench in New Jersey, she spent 4 years in juvenile court, and she was about to resign because she couldn't take anymore. And then she moved to criminal court. And then I watched her incredibly prepare for her tenure in district court, in criminal court. So it's a very steep learning curve. I know and understand that. And the amount of work that it takes to get up to speed is maybe more than many people appreciate or understand. And I sort of do that. That's through my sister and my first term here in the legislature. It's just like, what is going on here? So, with respect to your efforts, you're recognizing the criticism and pointing it out to us in a very level-headed manner, and to really seek to move forward and to be a better judge. I think everyone who's elevated to the bench wants to do their best. It's just a position that is. It's just a great thing to happen to your career, and to want to do better is always something that's interesting. So, I think that you need to continue to follow up on Senator Benning and Senator Nitka about a possible a mentor, and again, knowing some of the judges who have come back after being mentored and had accolades, it could be very beneficial after only 3 years on the bench. So those are the comments I wanted to make. I don't have any questions. One thing about going last, most of them have been asked already. So thank you for coming. Is everyone okay? No further questions from anyone? Okay, very good. Well, thank you, Judge. Thank you for coming in here and sharing your story with us. And we will we'll be back in touch with you, and we will move to Judge Valentine. And welcome, Judge Valentine.
Thank you for having me.
Yeah, so if you have a prepared statement, we would welcome it at this point.
Yes, please.
For questions.
Yeah, first, Chair Troiano and members of the committee, I do appreciate your time. I am very grateful for the role that the legislature plays in being a check and balance in our democratic system of government, and this is watching it play out in real time, and it's exciting to see. I've enjoyed being a fly on the wall for the last 2 nights. I've enjoyed hearing your comments and questions, and it's evident that the members of the committee have put a lot of time into this, and they take it very seriously, and appreciate that. I'd like to give you just a little bit of a sketch of my life story. Going to keep it short, and my path through my legal career, because I believe that both impact who I am, how I operate as a judge, and I believe they might also help address some of the survey responses. So I come from a family of very strong women. My Irish grandmother emigrated to the country when she was 18 and worked as a domestic servant in New York City until she married my Irish grandfather, who'd come over from County Cork. And even though he had been an accountant in Ireland, in the United States in the 1920s, the best job he could get was as a foreman in a lumber yard. They passed on a strong backbone to my mother, who, even though my parents divorced when I was a young adult, My father always credited my mother with being the driving force in the family to make sure that me and my three sisters would all go to college. And we all did. We were the first generation in our family to go on to college. And I'm incredibly proud of my sisters. One of whom right now is a public health director in the state of Connecticut. And so she has been on ground zero of the COVID fight. And again, I'm proud of her. I am married to a strong woman also. Some of you may have already met her. She's Judge Kirsten Schoonover. We were both appointed it'll be 6 years ago, the end of the summer, beginning of the fall, by Governor Shumlin. And we have two children. They're both in college. Our oldest, our daughter Anna, is a senior. She's a molecular biology major, and both her mother and I are scratching our heads on how in the world we ever produced such a scientist. Our son is a freshman in college, and so we are now officially empty nesters. Although they both came back to roost for quite a few months during the worst parts of the pandemic. I went to school in New York City, college and law school. In between, I worked as a community organizer in the Bronx. And coming out of law school, I landed my first job at a large law firm in Newark, New Jersey, where I worked for 5 or 6 years doing litigation, mostly federal court litigation. One of the biggest cases I worked on was we spent years trying to recoup. We represented the government of the Philippines, and we were trying to recoup the ill-gotten booty of Ferdinand and Imelda Marcos. Years of that, I determined that I really did not want to spend the rest of my life in New Jersey. I grew up in Connecticut, came up to Vermont a lot for skiing, but wound up going out to Washington State, where one of my sisters had moved to. And there I went to work for a small firm in Bellingham, Washington, northwestern Washington State. Reminds me a lot of Burlington, Vermont. And I had never studied family law in law school. I fancied myself, originally, I wanted to be a labor lawyer. And then when I went to work for the firm in New Jersey, because they had a labor department, what I wound up learning about myself as a lawyer was that I was a litigator. And that's what I liked. I liked the problem solving. I liked the challenges. I liked the meeting new people. So I went to this small firm in Washington, and they had a family law practice. And the associate went on maternity leave and never came back. And the partners turned to me and they asked me if I would be willing to pick up a family law caseload. And being a team player, I said yes. And I found my passion in the law. I really enjoy family law. I find that it is where some of our most fundamental societal relationships, the family and parent-child relationships, intersect with the law. And as a family law attorney, from that point until my appointment to the bench in 2015, I drew great satisfaction in helping people get through difficult stretches of the road. And one thing I saw as a family lawyer was that the adversarial model of dispute resolution that we use is not necessarily very well suited to resolving family issues. And so I took training. I often used mediation as a way to get cases resolved. I took training as a mediator. And I also became the Vermont State Bar Chair of the Collaborative Law Committee, which is another way of trying to resolve family disputes with less bloodshed and tears. And really enjoyed my practice, really enjoyed my colleagues, and in my experience, I probably appeared in every county in the state. For the first 6 years that I was in Vermont, I was in a boutique law firm that then merged with the biggest law firm in the state, Downs Racklin, and practiced family law exclusively. And what I saw there were judges that, as a judge now, I strive to emulate. And what they did, which I appreciated, because when you're walking into a family courtroom, your clients are often a mess, and I would appear before certain judges. You'd present your case, and these particular judges, whether they ruled in your favor or ruled against you, they explained why they were doing what they did. And I remember having a conversation walking out of courthouse. It was, I think this was when Judge Devine was a magistrate, and we lost. And my client afterwards said to me, Brian, I'm sorry we lost, but he explained it in a way where I understand that it's fair. And that's what I have attempted to emulate as a magistrate. As a magistrate, I practice primarily in Chittenden County, the busiest family courthouse in the state. I'm there 4 days a week. 1 day a week, I'm in Orange County, beautiful Orange County, and really enjoy that change of pace, change of scenery. It presents different issues. It's got rural poverty issues compared to many of Chittenden's urban poverty issues. I was amazed when I first got appointed at how much I was learning. Here I had been a family law attorney for 25 years. And almost every day I felt I was learning something new. The magistrates are a wonderful community. We're tight. There are 5 of us. We routinely bounce ideas off of each other. We try to present a consistent front on interpretation of the law, and they are a supportive bunch. I think I can probably attest to having been on the phone with Magistrate Lorman as he was going out onto the bench, as we were brainstorming a case or two. I've always found that the magistrates and the judges will drop anything to help new judges, or as we refer to them, baby judges. In addition to my duties as a magistrate, shortly after I was appointed, beginning in about January of 2017, Judge Grierson asked me if I would accept an appointment as a acting Superior Court family judge. This is not something I sought out, but he He asked me if I would do it. The other magistrate in Chittenden County, Barry Peterson, also does it. I know Magistrate Hoyt in the past has done it. And what the judiciary has done in the past is they'll tap into the magistrates. And I think especially if they have long family court experience, like Magistrate Peterson and I have. And so that's why I included as one of my writing examples a divorce decision that I did, just to show the sorts of complexity of issues that I confront in addition to my magistrate's duties. For the last 2 years at least, I've been in that acting judge capacity, one of the 2 judges every week that handles the relief from abuse calendar in Chittenden County. It's a busy calendar. Today we had 17 cases that the 2 judges had to get through before the noon hour. It's usually a little bit lighter than that. I have a long history in my legal practice with learning about and dealing with domestic violence issues. When I was in Washington State, before I moved from Washington to Vermont in 2000, I was for a brief period of time, 8 or 9 months, I was the lead staff attorney for a nonprofit that provided free legal service to victims of domestic violence. And in Vermont, I was appointed as the family bar representative on the Domestic Violence Council. It's going to sound a little strange. I enjoy the relief from abuse calendar. It's an important calendar, and I don't take the decisions that we make lightly. It is a calendar. It's intended to be summary in its format, meaning this is not the calendar for resolving complicated parental rights and parent-child contact issues that are better suited in a divorce hearing or a parentage hearing. It is really meant to protect people, safeguard people. And the statute is fairly narrow in what constitutes abuse under Vermont law. What constitutes abuse under Vermont law does not come close to encapsulating the universe of domestic violence. There are forms of domestic violence, social isolation, financial isolation, emotional abuse that don't rise to the definition of abuse under the statute. So the statute it's a tool. It's fairly narrow. I've been a bit surprised over the years of doing this that oftentimes I find myself denying requests because the elements aren't met. Much more often I grant the relief, and I have to say, being in Vermont, most of the defendants in those cases are men, and most of them are white men, and as a result, most of the relief from abuse orders I grant are against white men. I say this in context of one of the survey comments, which took me a bit by surprise, suggesting that I am biased towards white men in the relief from abuse context. as for training, one of the survey comments suggested some additional training on implicit bias. Implicit bias is very real. We all have it. The judiciary offers training on it, and we've had training on it. I had training on it when I went out to Reno, Nevada for my 2 weeks of general jurisdiction training when I first got appointed to the bar, to the bench. We've done training on it since then. It's a question of mindfulness and being aware of your biases. And so the other thing about being a judge, besides learning something new every day, you learn a lot about yourself. It's kind of like being a parent. And I appreciate the survey responses. This is my first retention. I've been on the bench about 5.5 years, and have gotten very little feedback from anyone on how you're doing. And so I really appreciate it. I take those survey comments very seriously. I think it leads to self-examination, and a life that, as the philosopher put it, a life that isn't self-examined isn't worth living. And so I think at this point, I would be humbled to be considered for retention. Judge Grierson mentioned a comment that he got from a couple of judges when he got appointed, and I got the same comment. Judges writing to you, congratulating you, saying, welcome to the best legal job of your career. And it really is. As much as I enjoyed being an advocate and being a lawyer, I think being on the bench gives me the opportunity to have much more impact on the lives of families and children in the state of Vermont. Let me just address a couple of other points, and then I'd be happy to answer your questions. One of my survey responses suggested that I take matters under advisement rather than make difficult decisions on the bench. I would first point out that I never take a relief from abuse case under advisement. Those are cases that have to be ruled on right then and there. I can't remember taking a single one under advisement. Occasionally, you get a child support case or a divorce case where the evidence is so voluminous, and in the child support realm, it often is documentary, tax returns, corporate tax returns, bank statements, financial affidavits, pay stubs, that you, at the end of a 1 or 2 hour hearing, when all you've heard is testimony and the attorneys handing up exhibits, often by stipulation, with barely a explanation of their significance, you just have to take some time. And I try to do that. Occasionally, and I am mindful of the saying that justice delayed is justice denied, but magistrates also have a unique charge. Unlike other Superior Court judges, we are charged with an affirmative responsibility to develop the record before us. And so sometimes you have a pro se litigant or a self-represented litigant. up against a case where the other side is represented by an attorney, and the self-represented litigant has simply not gotten the information that you need. They've not gotten you the documents that you need to be able to properly weigh the case. And if that's the case, despite the protestations of the attorney, I will sometimes continue the matter and issue a discovery order, spelling out to the self-represented litigant exactly what I need. And we'll talk about what I'm looking for, so that we have all the information before us. I think it's much more important to take a little extra time and effort to get that information than to do I hate to say it, a garbage in, garbage out decision. So I think at this point, I would respectfully request that I be retained as a magistrate judge, and I would be happy to answer your questions.
Very good. Thank you, Judge. So we'll look to Senator Hardy. Would you like to start it off this time and ask some questions of the judge?
Sure. Thank you, Mr. Chair. And thank you, Magistrate Valentine, for being here. You're from Huntington, which is in my district.
Yes.
Yes, but despite...
I was going to say that I appreciate your front porch forum postings.
Well, thank you. Thank you. I appreciate the fireman's dinner. I'm really, thank you for being here and for your work as a magistrate. I'm really interested in the comments you just made. Actually, you didn't address it so much in your application or your letters, but the narrow definition of domestic violence and how that often, or at least sometimes, may prevent you from issuing a relief from abuse order. And is that something you think we as the legislature should address?
Okay, so let me give you a real thumbnail sketch of the statute. The definition of abuse is contained in Section 15, Title 15, Section 1101 of the Vermont Statutes Annotated. And it defines as being the occurrence of one or more of the following acts between family or household members. So that's the first hurdle. It has to be between family or household members. And the case law has interpreted what is a family member. And household members, sometimes I have cases in Chittenden, I only do the relief from abuse. In Orange, I do civil stalking also. My special appointment includes that also. Sometimes you have situations where people don't meet the definition of family. It's a in-law. It is a step parent, or that doesn't reside in the household with the plaintiff. Then the definitions are: abuse means attempting to cause or causing physical harm. Did he hit you? Did he try to hit you? That's a far cry from controlling behavior, which is sort of a hallmark of domestic violence. The second definition is placing another in fear of imminent serious physical harm. Did he threaten to kill you? Then there is abuse to children, as if somebody's seeking a relief from abuse order on behalf of children. And the definition of abuse of a child is actually higher. It's harder to get an order protecting a child than protecting yourself. Stalking, and the stalking statute was recently expanded, and it is stalking behavior. There are lots of ways to find a reason to put a relief from abuse order in place if there's stalking behavior. I think that has actually been I often go to that. If I see a situation, I know it's not a good situation, but they haven't met the obvious grounds for relief from abuse, I'll go down the stalking approach and go through the elements of stalking. And then the last one is sexual assault as defined by the criminal statute. So is there a legislative fix? I don't know. I think that the expansion of the definition of stalking helped. I think perhaps an additional example of abuse containing some of the more classic controlling behavior might be helpful. I've often thought when litigants are filling out the complaint, it would be really nice. I think it would be helpful if they incorporated something like the trauma assessment or lethality assessment that certain experts use, because those are red flags.
Okay.
So perhaps an expansion of the complaint form too might be helpful.
Okay, that's helpful. It sounds like it mostly focuses on physical abuse or the threats of physical abuse, and there's, as we all know, more types of abuse, psychological, emotional, financial, etc.
Yeah.
So I will definitely take a look at that. Our legislative counsel attorney is on this call, so I can talk to him about it another time. I appreciate you bringing that up. I also appreciated your comments about implicit bias being, an exercise in mindfulness, and I'm certain that it must be difficult to maintain mindfulness and be aware of implicit biases when you're trying to get through 17 cases before noon, which you said you had to do today. I know when we're rushed as legislators, this morning I was super cranky in my committee, and we're just trying to get through a lot these days. And so that's when biases often come out. So
you're absolutely right. And one element of the implicit bias training that really struck with me was when you are making a gut decision, when you're relying on your instincts, and when you are under time constraints, we tend to rely on our gut.
Exactly.
And that's where the implicit bias really reveals itself.
You're absolutely right. And we're all guilty of that. So I appreciate you being aware of that. I'm going to cede the floor to one of my colleagues so I don't take up all the questions.
It's nice to meet you. Maybe I'll see you at Beaudry someday.
Yeah, absolutely. Thank you.
Thank you, Senator. Representative Knott, do you have some questions for the judge?
I don't have any questions at this time. Thank you.
Questions. Okay. Senator Benning, would you like to inquire?
Well, Magistrate Valentine, I'm glad to hear that you're a Rotarian. I did not actually have any pertinent questions. I did have two very brief observations. One is to say that I made the decision to get out of New Jersey as soon as I could, about the age of 10. In Bellingham, Washington, the Chuckanut Highway is one of my most favorite places to ride a motorcycle.
Oh, I bet.
With that, I need to alert the chair that I have two other obligations this evening, and I've got to be off this conference by 7.
Okay.
Thank you, Magistrate Valentine.
Thank you, Senator. And actually, I was a Kiwanian.
All right, thank you. Representative Shaw, do you have any questions for this judge?
More of a comment than a question, I think, Representative Chair. So, Judge Valentine, I guess it's becoming my go-to question, but I noted in your declaration as the negative part of the job was that it's sedentary and solitary. And I'm curious, as you state in the fire department, but had to give up other exercises, and just can you just comment on that and how maybe you handle that?
Yes, yeah, and it was a so as a lawyer, most of my friends were lawyers, and you socialized with your colleagues. As a judge, you can't go to Stone Corral and have a beer with Matt Buckley, who's a family law attorney who happened to have been your friend, because he may be before you the next day, and that creates an appearance of impropriety. If anybody said, "I think I saw the judge having a beer with her lawyer," so I've had to eliminate those social interactions. Fortunately, a very dear friend of mine, who was my mentor in doing probate and estate planning, which was also an area of practice that I did. He's never going to step foot in family court. And so I do get to see him and have companionship. I did have to drop off a non-for-profit because board members fundraise. And that also would be an ethical lapse. And still a member of the organization, still go out there and hike in the woods and put binoculars around my neck, but I'm no longer on the board. Fortunately, I was able to remain on the fire department. We didn't see how that was going to really create any kind of conflict. And that's something that I've just really enjoyed. I've been on the department in Huntington for over 15 years now. And a great bunch of non-lawyer, non-judges to hang out with. And it's very satisfying. I'm pleased to report that it has minimal impact on my judging. I've never had to leave the bench to go respond to a call. Wouldn't do that. And at most, sometimes maybe I'm a little groggy in the morning if I've been up at 2 or 3 o'clock in the morning responding to a medical emergency. We're a first response agency in Huntington, so we don't have an ambulance. We don't take our patients into Fletcher UVM Medical Center. We assess the situation. We apply first aid. We start gathering history. We take vital signs, and then when Richmond Rescue shows up with their ambulance, we transfer patient care and we go home and we go to bed. Otherwise, wellness is I think it's an issue with judges. We focus on it at Judicial College every summer, when we still had Judicial College in the summer. Me personally, I get up in the morning and I meditate, and I try to exercise as often as possible. I was training for my first Vermont City Marathon this time last year when they postponed it. And so I do a lot of cross-country skiing.
So there are some avenues socially that you can have identified that you can partake of. And thank you for your
And
service.
I'm very fortunate too to have a wife who's a judge. We kick back, we tell each other about each other's day, compare notes, review decisions.
Very cool.
It's been wonderful.
Thank you for your service in the fire service, because that's an advocacy of mine. I've been in my local department 52 years. So.
Fantastic.
And I agree. It's a great way to relieve stress.
Yeah.
Thank you.
Thank you.
Thank you, Representative. Senator McConnell, you have, McCormick. Sorry.
That was really funny.
As mistakes go. Let me just catch my breath on that. Your comment where you said, I really enjoy family law. I've had lawyer friends who have said the exact opposite, that it's the worst kind of law.
It's almost a perversion. I know so many lawyers who started out with some family law because there's a lot of work out there to do. And as soon as they develop a lucrative practice in another area, they're out. They're doing real estate closings. They're doing personal injury. I genuinely enjoyed it and genuinely find it very, very satisfying.
Well, okay, getting to something less mysterious. As someone else mentioned that even judges who are getting overwhelmingly good reviews, and you've got your charts are good, your numbers are good. When I saw the first person who said, I don't think they said necessarily that you had a bias in favor of abusive white males, but that you were bullied. You allowed yourself to be bullied by abusive white males. And that was one. And then I saw that the next comment said much the same thing. And I thought, okay, there's a pattern emerging. And then the comment after that was how masterful you are at maintaining order in the court. So
I scratched my head over those two.
Okay. But what I would say is that there's someone has identified a problem which may not be pervasive, but it's something there sometimes at least. Would you comment on?
Yes, and thank you for
maintaining order in maintaining order in the court and abuse of white guys.
Yeah, and thank you for giving me that opportunity. When I was a lawyer, what irritated me so much was when you finished having a hearing and the judge had ruled from the bench in your favor, and the other attorney jumps up and just starts arguing with the judge and arguing with the judge and arguing with the judge. And this is a technique. And the judge starts giving some concessions, not turning their ruling over, but maybe, okay. So how about we just, instead of this Friday to Sunday, we'll make it Friday to Monday morning when you have the child. I recognize that. I hated it as a lawyer. I get it. Tried on me as a judge. And I try not to reinforce that kind of behavior. I've recently said to a lawyer, argue to me, don't argue with me. Mm-hmm. So yes, oftentimes when you're ruling from the bench, it creates a whole kerfuffle where somebody's very disappointed or not happy. And they, with self-represented litigants, sometimes they'll get loud, sometimes they'll stand up. I've had my court officer escort someone out of the courtroom. I think it is abusive behavior. So if I'm sure it's happened, because I know instances where I've had litigants like this. I try to kill people with kindness. And I try not to elevate the emotional pitch in the courtroom. And if that's perceived as letting somebody blow off steam abusively, I'm sure it's happened. It's not something I like. It's not something I should tolerate. And I try not to. And I now realize that I need to try harder.
I know as a politician, one of the biggest challenges for me is how to deal with angry people, because you can get accused of being a bully where really all you've done is refused to be bullied. But if the bully really wants to bully you, then he can instantly become a victim. if you resist the bullying, and poor, and I'm sure most politicians, at one time or another, someone will tell you you're condescending, and it's simply because you just won the argument, but now you're condescending. But you, as a judge, you got the gavel. I mean, you don't have to take that, right?
Yeah.
Just,
and you know what we're doing now? And I've done this a couple of times already now with the remote hearings. When I get somebody who's out of control and they won't shut up after you've told them, sir, we're going to do this one person at a time. If you keep interrupting, I'm going to mute you. And that works. You get better behavior.
yeah. Of course, you don't want to be too quick to do that. It really is walking a tightrope.
No. I used to referee youth soccer, and the 2 yellow card rule is a good one.
Okay.
Thank you.
I guess that's all I have. Thank you.
Thank you, Senator McCormick. And Representative Coburn.
I think my questions have been asked. So I'm all set. Thank you very much.
Okay, thank you. Senator Nitka.
So we certainly have heard a lot here tonight, and I had a little bit of a focus on the same thing as Senator McCormick with regard to, abusive people acting up in the courtroom. And it reminds me of substitute teaching. When a substitute teacher comes in and if they don't get control right in the beginning, they generally don't get it. They can't recover that group. And it sort of reminds me of that. And I'm not sure if there's something you could do a little bit differently. I mean, these probably don't happen every day, but that might be the approach when you think of the substitute teacher and how people handle that in terms of taking charge right away. And I have to admit, I like your idea of muting someone. Just because, you can say, if you don't continue, I'm going to mute you. And if you're ready to go ahead,
Yeah. And so maybe one of the approaches would be at the outset, laying out some of those ground rules.
Not a bad idea. Yeah.
Yeah. And I don't think I've done that. I think I've only done it when it's happening and I have to say, whoa, keep that up. I'm going to mute you. But I think if they come in knowing, look, this is going to be a respectful conversation. And if you can't do that, you're not going to participate.
So it really sounds like educating them before it starts, which sounds like a good idea. The other thing, you've spoken about a lot of issues. One of the other ones I also noticed that was a concern was timely decisions. And as with everybody, that's a really difficult.
Yeah, it's the bane. It's the bane of judges. Like Magistrate Lorman, I'm now down to one day a month for findings. And I'll be perfectly honest, it's not enough.
It's not.
And prior to the pandemic, I had more time. I gave that up in order to help dig out the backlog of cases. But I miss having that opportunity. I like to spread out. When I have 30 exhibits, I like to spread them out and walk around the table and walk away from the table and come back and think things through. I don't. No, I think I'll leave my comment to that. Unless you have another question.
No, it just seems like that's an area to work on, and I don't see it's going to get much better for anybody when they're, when the courts reopen. But maybe, I don't know. But I think that's something to be constantly aware of, because that's an area that just always needs to be kept up to speed, it seems.
Yeah. I keep a whiteboard in my office, with every case. So I've got that constant shaming.
Good. Thank you very much.
Thank you, Senator.
Thank you, Senator. I actually picked up on the same three comments that Senator McCormick did, and thought they were kind of interesting. But I think you've explained those pretty well. I don't really have any questions for you, Judge. I think that there was a recommendation, 100% recommendation for your retention. I think overall your remarks and comments were pretty positive. I don't really have any comments. I think that again, as you just covered, writing takes time and effort, and especially at a time now when our family courts are crowded, our dockets are backed up, and things have gotten so much more involved. I guess we can appreciate those who go into work every day and face those issues.
Yeah. If I could throw in a comment.
Yeah, sure.
All right. And this came up yesterday with Senator Benning asking about the vaccination of court personnel. And I realized that that's an executive branch decision. Me personally, because I'm an EMT, I'm already vaccinated. And I've got to tell you, it takes a load off of your mind. Here in Chittenden County, we have 2 docket clerks right now out with COVID-19. The wheels of justice grind to a halt without our docket clerks. I'm not so concerned. As a judge, I'm handling a lot of my matters remotely. I'm not within 6 feet of anyone. But consideration of getting the staff vaccinated, I think that would, if at all be possible, would take some of their anxiety away, and probably speed the wheels of justice to get turning again.
Good to hear. Thank you.
Odd to hear you say that, Magistrate Valentine, because I just received my second in 2 days notification of an incarcerated client who now has COVID-19.
Oh.
And this judicial branch has got to be taken more seriously than being left to dangle with everybody else in the population. I don't understand why there's not a lot more noise about it.
Yeah. On that piece, the Department of Corrections has specifically asked us magistrates who do contempt work not to issue minimuses. Don't send people into the system because they have to quarantine, and they take up some of the very limited quarantine beds. It's impacted our ability to use contempt as an enforcement device. But it makes perfect sense.
Well, thank you for that gratuitous comment. I hope it's carried through the rest of the folks on the screen.
Okay. Is there anything else from any of the members of the committee? Okay, hearing none. Judge Hoyt, Judge Lorman, Judge Valentine, thanks all for being here this evening. It's been a pleasure to meet with you and to, yes, Senator Benton.
Yep, this just dawned on me. Judge Grierson has been on the screen, and I'm wondering if we could ask him a question before we let Magistrate Lorman go. Okay. I did not want to see us make the suggestion that perhaps having a bench meeting with the staff was a good idea without hearing from Judge Grierson whether that's even possible. I didn't want to have him go off with some expectation and have us thinking that that might happen and that couldn't for some reason that I don't know of.
Yes, good idea, Joe. Judge Grierson. You're muted.
Not really.
There, is that better?
That's
Yes.
better.
Thank you, Senator Benning, and thank you, Chair Triano. What I'm going to do is to work with Terry Scott. She's the Chief of Trial Court Operations, and she supervises the staffs in all the courts. And I will talk with her, explain to her what the discussion was tonight. And I'm certainly not opposed to the idea, but I want to be careful with staff and the position it puts Judge Lorman in doing that. So I think it can be done, but it's got to be done the right way. And so I'd want to work with Terry Scott and the court operations managers in each of the courts he works in to make sure that it's done in a way that everyone feels comfortable. So we can explore that over the next week or so to find out what we can do. But I've already reached out to Bob Paolini while the hearing was going on tonight to talk about some ideas about putting a formalized plan together to present to the committee. Obviously, we've got to sit down with Judge Lorman, and I've got to look into any other training or education pieces that we can perhaps put in. And finally, I think working with the Magistrate Hoyt, Judge Hoyt, is important if that's the mentor he's had. I'm also looking into the possibility of bringing on a retired magistrate for observation. I think what many judges lose when they leave the orientation period and go on to the bench is the opportunity to be observed. And that is something that we have to work on. And I think as I'm listening to I did not have access to Judge Lorman's survey, so I'm not familiar with all of the comments, and I would like to review that myself and come up with a plan that addresses the issues raised by those comments and some of the questions and answers I've heard tonight. So we will put together a plan, hopefully that'll be satisfactory to the committee to address the issues that have been raised and discussed here tonight.
I just want to make clear, it wasn't, from my perspective, the survey results from the attorneys were not as alarming for somebody who's
Right.
only been on the bench for 3 years. That didn't surprise me anyway.
Right.
There are certainly things that can be worked on there, but the overwhelming concern that I had was the actual dealing between the court and the staff. And I don't think I've ever seen that before in one of these surveys. And I'm not sure how you mentor that situation. So I raised the suggestion of a direct face-to-face meeting only because I know for I think all of us on this screen who have dealt with constituents, and certainly me in the court situation where I've had court officers or people who have been on the bench that have had conflict of some kind, face-to-face meeting has always worked. And so I raised that as a suggestion. I don't know that that requires a mentor.
No, and I wasn't thinking of the traditional mentor piece because I said he already has Magistrate Hoyt that he can reach out to. What I'm thinking, at least what I heard tonight, and again, I'll have to review the survey results, but I was particularly concerned about the issues as they relate to staff and relationship with staff. But some of those issues seem to be involved in the way he conducts himself in and around the courtroom. And I was thinking not so much as a mentor per se, as truly being observed in how he conducts himself in the courtroom. And quite frankly, if the schedule is out for the day, that person following him even for a day would be able to track, is he starting the hearings on time according to the schedule? And so I heard a lot of things tonight that I think he could benefit from an experienced judicial officer observing him in his day-to-day proceedings. But I agree with you, the staff issues are the most concerning. That's why I want to work with Terry Scott to see how best we can address those.
In Magistrate Lorman's defense, that number was quite finite. So I didn't see that as an impossible task. It may just be one courthouse for all that I know, but it's certainly something that causes concern when you first look at it.
And I understand, and I appreciate that. And one of the issues that we've got to try to get our hands around is because he works in 3 courts, we need to address, could be one from each court for all I know. I don't think we'll be able to determine that necessarily. So,
And Magistrate Lorman, sorry to talk about you in the third person like this, but Judge Grierson and I go way back. So in fact, we both had hair at the time we first met.
Not at all, Senator. Thank you.
we did. We actually did. Believe it or not, we did. The good old days.
Dick, did you have something you wanted to say?
Yeah, since Judge Grierson is here, we're now dealing with someone where there were some complaints. We don't want to ignore them. We also want to help make things better rather than get, punitive and so on. We faced a similar situation 2 years ago with another judge, and we resolved the issue with mentoring. I think is relevant to this. If we could get some kind of report on how that's going, and it's not to check up on the judge, it's to check up on the solution, the efficacy of the mentoring, because there was some serious concern, and that was how we addressed it.
No, I certainly remember the case. I'm interested in what you're really looking for at this point, Senator McCormick.
Well, we're thinking of doing taking a similar approach first with a similar issue. And so I'd just like to know if
it was effective.
Going well. Yeah. Is it going well?
Right. And so I do have information on how that went. And from everything I have read and been provided, there was a period of monitoring, a fairly lengthy period as I recall it, but I certainly remember the case and the response. And that's why, as I was listening to the testimony tonight, I reached out to Bob Paolini and said, we've got to, put together a formal plan, and what might it look like?
Yeah.
Senator Hardy, you have your hand up, yes?
Yeah, thank you, Mr. Chairman. And thank you, Judge Grierson, for hearing our comments, and specifically my comment about wanting a specific plan. And apologies, Magistrate Lorman, I know this must be awkward, so I'm sorry. But with all due respect to my colleague, I think that this situation is actually different than the one we dealt with 2 years ago. And I wouldn't want to equate the two. My concerns are certainly different. I would love to hear from you how things are going with that particular situation and how the mentoring worked. But I think the issues, and you don't know because you haven't read the file, but the issues are different. And maybe a similar plan is called for, but they are different issues.
No, I understand they are different issues from not only listening tonight, but talking with Bob Paolini. The only way I think the issues 2 years ago were serious. These are serious, but they're serious in a different vein. And right. So I think we can put together a plan, but I think it will have different components than we had in the previous plan. And right. As long as I have you on the screen, I will tell you that in response to some of the comments last night, I'll be glad to reach out to you to talk to you about that plan and what happened as a result of that. And we say that when we see these comments that are adverse, we sometimes don't know what's behind them, and we don't get a chance to talk with the people because they're anonymous. And the concerns you expressed to me last night are something that you and I can talk about because we can talk. And so I'll be in touch with you about those comments as well as the situation that's presented here tonight, if that's acceptable to you.
Thank you.
I would concur. They are very different situations.
Yeah.
Yeah, we need to take a look at how we might respond to this. McCormick, your hand is.
Just for the sake of clarity, to say the two things have similarities is not to equate the two.
Right.
And absolutely, these are different situations. All analogies limp. I'm pointing out that they have something in common, namely that there is a problem and that we look at addressing it with mentoring. Those are similarities. They are not equations.
Okay. Thank you, Senator. So I think that concludes our business. Peggy, did we get the notice to the public hearing for the public hearing out?
Yep, that'll go out tomorrow morning.
Okay. So that'll be the next thing on our committee agenda is the public hearing
Yes, on the 10th of March.
on the 10th of March. Okay. Yep. So until the 10th of March, we will recess this hearing.